appeal in the matter of Stephenson and the First-tier Tribunal Social Entitlement Chamber.
Yes, Mr. Curry.
Good morning, my lords. I appear on behalf of the applicant with my junior, Skander. The respondent, the First-tier Tribunal, is not present, but Ms. Lorraine appears on behalf of the Criminal Injuries Compensation Authority.
Yes.
My lords, I hope you have two bundles, one larger than the other. The larger one is the authorities bundle,
Yes.
And the first one is the core bundle.
Indeed we do.
I'm grateful. My lords, you will have had both our skeleton arguments. The issues are threefold in terms of the appeal that's mounted by the appellant. The first ground is in relation to the misdirection or misinterpretation of paragraph 42B of the Criminal Injuries Compensation Scheme 2001, which I'll call the 2001 scheme from now. Insofar as it related to adaptations to a property and costs relating to a Court of Protection Property and Affairs deputy. The second, in the alternative, a ground of appeal is that if you're not with me on the first point, then in fact, even importing the wording of Upper Tribunal Judge West, the costs of the Court of Protection and the adaptations are inclusive because they follow from the resulting loss of parental services. And there's a final ground in relation to the costs of an extension, which my junior will be dealing with in due course.
Yes.
I'm grateful. My lords, in terms of a factual background, you will see that this application, the appellant is Dominic Stephenson. There is a brief outline in the First-tier Tribunal judge's determination. It's core bundle 119, but essentially he is now a 28-year-old gentleman who suffers from Kabuki syndrome, which results in is a congenital disability, a relatively rare one. He also suffers from a mild learning disability and a severe development delay. He's incontinent, that's the reason for the adaptations, and benefits from a property and affairs deputy.
Just property and affairs, or does he have a welfare deputy as well?
Just property and affairs, my lord. And that is the litigation friend Victoria Tracy, who is his maternal aunt. My lords would have seen that the index incident occurred on the 3rd of January of 2005, where his father killed his mother, father being convicted of manslaughter, and Dominic was 7 years old at that relevant time.
And in the house at the time? In the house at the time?
Yes. There's limited information in the bundle in terms of that index incident, but it was quite horrific. Dominic then moved with his maternal aunt, with his siblings, again the litigation friend, and brought a claim on his behalf, Tracy, the litigation friend, on the 1st of April of 2005. At the same time, my lordships, you will have seen that he also mounted a claim under the Fatal Accidents Act, which was settled where he received circa £38,000. That's referred to in the first decision of the CICA, which I'll take you to in due course. But for your
that was
reference,
a claim against the father, was it?
it was a claim against the hospital trust. That claim was mounted on the basis that there was a failure to have released the father in circumstances where they would have known of his mental condition.
Do we have anywhere a basis on which that sum was reached?
I have.
It was a settlement, but it had to be approved, no doubt.
Yes, I have a consent order, my lord, which isn't in the bundle, but certainly can be provided.
Well, if all it says is by consent, the defendant is to pay
Yes.
£38,000 or so, that wouldn't tell me anything. But do we know how that figure was reached?
I don't have instructions. I can find out, my lord, but we've been able to obtain the consent order, but I can ask those instructing me to dig a bit further to ascertain how. Yes. I'm being told that the file has been archived at Erwin Mitchell's, who were the solicitor who represented him. So it's going to be very difficult to obtain further papers, but we've been able to obtain the consent order at the very least.
The only thing, there would be an advice which council would have prepared
Yes.
for the court hearing. If that could be found, excellent. If it can't, don't know.
I'm grateful. We'll make inquiries. My lords, thereafter, in this brief chronology, the decision of the CICA, the first decision, was of the 11th of January 2026, which is in the core bundle, page 130.
January.
2016.
2016.
You said 2026.
Forgive me. 11th of January 2016.
Core bundle.
Core bundle 130.
Thank you.
Thereafter, there was an appeal to the First-tier Tribunal on the 4th of October 2018, core bundle 120. That was then quashed by the Upper Tribunal and remitted back to the First-tier Tribunal, who made, after a fresh hearing, a decision on the 24th of August 2022, core bundle 118. We then have the impugned decision of the Upper Tribunal of the 5th of March 2024 of Upper Tribunal Judge West at core bundle 32. And your lordships would have seen the permission was granted by this court on the 31st of October of last year. My lords, my intention is that to briefly take you through the schemes, or in particular the 2001 scheme. The white paper is in the bundle which has been referred to in the skeleton argument, and to then develop the three arguments that are made on behalf of Dominic.
Yes.
My lords, I mentioned the white paper. It's set out in the appellant's skeleton argument, but insofar as reference is required, in the authorities bundle, the white paper of 1993, page 10 of the authorities bundle.
Is the electronic bundle the same numbering?
My lord, it should be, yes, for that
Did you
bundle.
say page 93?
Page 10.
Page 10, sorry.
This is the white paper of December 1993.
Oh, that's right. Thank you.
My lords, I simply refer to this paragraph 4, page 11. It's marked up in terms of the basis and the remit of the scheme. If I could ask your lordships just to briefly read paragraph 4.
Yes.
I'm grateful. The statutory underpinning, therefore, of the scheme is contained under the Criminal Injuries Compensation Act 1995, which your lordships will find at page 24 of the bundle. It provides, and I paraphrase paragraph 1.1, that the Secretary of State shall make arrangements for the payment of compensation in respect of persons who have sustained one or more criminal injuries, and number 2, that any such arrangement shall include making of a scheme. The relevant scheme is in the bundle at 198, which is the 2001 scheme. And I'll just take your lordships briefly through what I consider to be relevant paragraphs. Page 201, paragraph 2 provides for the operation of the scheme by the claims officer, who will determine how the compensation is to be made in accordance with the scheme. Paragraph 6 on the same page provides that the compensation may be paid in accordance with this scheme to an applicant who sustained a criminal injury, which plainly this appellant is not in that category, or where the victim of a criminal injury sustained on or after the 1st of August and has since died, and the applicant is a qualifying claimant, which there is no dispute that the appellant is. There are relevant prohibitions to the scheme at paragraph 13, page 202. None of which it is said are relevant in this appeal or the application. And the ambit of the compensation is set out at paragraph 23 on page 204. And the relevant paragraph for these purposes in my submission is paragraph 23D, which is where the victim has died in consequence of the injury, the amount of claims calculated in accordance with paragraphs 37 to 43.
Yeah.
My lords, paragraph 24 provides on the same page of a maximum cap in the amount that can be awarded of £500,000. The next relevant part is paragraph 35 at page 206, which, whilst not applicable to the appellant, is relevant by way of background in my submission, because this relates to an applicant who's been injured and has a loss of earnings claim, for instance, and under paragraph 35D is able to claim, you will see adaptations on the second bullet point to the applicant's accommodation, and finally the costs of the court of protection for the curated monarch. That provision obviously doesn't apply to the appellant because he's a victim of a qualifying claimant. The compensation in respect of fatal cases, which is the relevant passages, are found under at page 207, paragraph 37 onwards. And paragraph 38 is the gateway provision in defining, in my submission, the qualifying claimant. And what is a qualifying claimant? And for these purposes, the appellant falls within the 38C, a natural child of the deceased, or a person who is not the child, a natural child, provided he was accepted by the deceased as a child of the family or was dependent on him. And then it follows in the next paragraph that where the victim has died in consequence of the injury, compensation may be payable to a qualifying claimant under paragraphs 39 and 42. Open brackets, standard amount of compensation, dependency and loss of parent, close brackets. And the relevant paragraph is that of 42, my lords, which you would have seen in all the documentation, which essentially provides three gatekeeper criteria, if I can call it that way. Number one, that the applicant must be a qualifying claimant, which there is no dispute the appellant was. he was under the age of 18, that he also was, and he was dependent on parental services, which it is also undisputed that he was. The first part of the claim that he's entitled to is the loss of parental services at an annual rate of level 5 of the tariff,
How much is that these days?
£5,000. And that tariff is found at page 216, which is an annex to the scheme. And then your lordships will see that 42B provides for such other payments as the claim officer considers reasonable to meet other resultant losses. And this appeal,
Did you say 5,000? I think it says 2,000.
2000.
Sorry, yes, you were saying.
No, my lord. So paragraph 42B provides, as I say, that such other payments as a claim officer considers reasonable to meet other resultant losses. And much of this appeal is on the pinhead of the interpretation of the words other against the context of paragraph 42 and in the context of my submission of what is permissible if someone is injured, as I've set out in paragraph 35 of the scheme. My lords, that is the scheme, the relevant scheme. There are many other schemes which I just briefly would like to take you to. The first is the 1996 scheme, which your lordships will find in the bundle at 218. And the relevant paragraph, comparable to the paragraph 42, is in fact again paragraph 42 at page 227.
So, sorry, what date is this one?
This is the 1996 scheme, my lord. Commences at 218 and paragraph 42 is at 227. I need not take you to the specific wordings of that paragraph, suffice to say that they are identical in terms. Leapfrogging then the 2001 scheme, and if I could take you to the 2008 scheme, which is at the bundle at 236. The germane paragraph again is paragraph 42, and that's at page 249. And again, similar wording is found at 42B, other such payments as a claim officer considers reasonable to meet other resultant losses. Then to the final scheme, which is the 2020, Upper Tribunal Judge West considered in some detail. That is at page 259. And the relevant paragraph this time has altered in number. It is paragraph 65 at page 277. And paragraph 65A, in similar terms, but now quantifies, without reference to a tariff, £2,000 for each year. And paragraph B, any such amount in relation to any expenses suffered by a child as a direct result of the loss of parental services as the claim officer considers reasonable. So your lordships will see there that there's been an importation of words of direct direct result of the loss of parental services. The next part of the rubric is the fatal guides which are contained in the bundle. The first being the fatal guide of 2001, so relevant to the scheme in question, which is at page 124. And you will see at the front of that page that it provides for it being issued by the Criminal Injuries Compensation Authority. Just by way of background, in the introduction, it provides under paragraphs 1 and 3 that the guide explains in paragraph 2 in particular, page 125, that the guide explains the circumstances in which you may claim for compensation and tells you how it is calculated. And in the next sentence, halfway through, it is simply aimed at enabling you to understand how these provisions work and to make a claim with as little trouble as possible. The purpose being that it's intended that one is able to claim for under these schemes by yourself. So if you are a victim, it should be easy to make a claim without legal representation. But the relevant paragraphs in terms of paragraph 42 is the guide at paragraph 13 on page 127. And the first part of that sentence relates to paragraph 42A of the 2001 scheme, namely that the qualifying claimant can claim that annual rate of level 5, currently £2,000. And the second sentence relates to paragraph 42B in my submission, which is that compensation may also be payable to meet other resultant losses. For example, any additional costs of childcare or loss of earnings suffered by an adult in looking after the child. An appropriate multiplier applied to the period until the child reaches the age of 18 will be used. So that multiplier giving the flexibility of considering the individual circumstances of the qualifying claimant.
As drafted, it looks as though it's a regular sum that's envisaged with a multiplier rather than a one-off.
In my submission, my lord, it's both the one-off award under the tariff, but also the other claim that may be sought under 42B.
The scheme envisaged, the way 42 is drafted, and the way 42 is drafted envisages that the sums will be multiplied by the appropriate multiplier.
My lord, if I can go back to the scheme to answer your question, the scheme at page 208, paragraph 42, last paragraph provides that each of these payments, so the tariff award as well as the other resultant losses award, will be multiplied by an appropriate multiplier selected by a claims officer in accordance with paragraph 32.
Yes, my point was that the way that's drafted doesn't seem to envisage one-off payments, but rather that 42B would cover regular
Yes.
payments over and above the tariff
My lord, yes. I entirely agree with that interpretation. And justification of that is by reference of the additional costs of childcare, by way of example, or loss of earnings suffered by the adult who's looking after the child. And in this case, obviously, the child or the qualifying claimant is a disabled child, and as a consequence of that, all the things that come with looking after a disabled child, which in this case relates to the adaptations and the court protection costs arising because he lacks capacity to make decisions in respect of his property affairs. My lords, the final piece of the puzzle, if I can put it that way, is the 2005 Fatal Guide, which is in the Authorities Bundle at page 132. And I refer to this in the same way as I refer to the previous schemes and the schemes that followed the 2001 scheme. This obviously wasn't relevant at the time of the 2001 scheme, but the relevant paragraph one finds at paragraph 41 at page 141. And paragraph 41 at page 141 reflects what has been said in respect to 42A, but paragraph 42 at page 142 reflects 42B, insofar as we may also be able to pay compensation for other resulting losses, for example, the extra costs of childcare, of an adult's loss of earnings due to looking after a child. When we finally assess the claim, we will take full account of any losses that have taken place up to that point. Again, in my respectful submission, providing for the opportunity of compensation of losses suffered by way of looking after a child. My lords, in the bundle also are references to a textbook by Laura Begley, in criminal injuries compensation claims. There are two editions included. The first edition is 2005, which is the only one we've been able to find going back that period of time. But you'll find that, my lords, commencing at page 239 of the Authorities Bundle.
239.
239. So 293. Forgive me, I'm mixing my numbers today. And the relevant analysis of paragraph 42B is contained at page 311 under the heading of other resultant losses. And if I could just ask you to read the first paragraph of under the heading of 12.6.3 other resultant losses. The text in my submission identifies a lacuna, which some analysis is given over the page, which is marked up at page 312, at the bottom of the paragraph before it commences awards, post-dating an award. And the relevant sentence onwards is the difficulty with this argument. And it starts, it is more likely that this provision, 42b, could legitimately be used to permit the authority in less unusual cases where the qualifying claimant child was, for example, already very disabled and required extensive care from the deceased parent, which is now provided by another, to make an award reflecting this extra level of care as compared to an able-bodied, non-disabled child. And that is exactly the applicant's point. That is reflected again in my respectful submission in the 2006 version, which is then the second edition, which commences at page 318.
That talks about level of care. Does it say anything about accommodation?
I don't believe it does, my lord.
Okay, thank you.
And the corresponding and most recent edition, as I say, is the second edition, commences at page 318, and the relevant paragraph is at page 340. And halfway through the first paragraph at 340, it says, again, it is more likely that this provision could legitimately be used to permit authority in less unusual cases where the qualifying claimant child used to permit the authority in less, for example,
the
already
difficulty
very
with this
disabled.
argument, what argument?
My lord, this is at page 340,
Yes.
first paragraph at the top of the page, and halfway through that paragraph, a sentence commencing, it is more likely.
Yeah.
7.
And there's a reference to a case,
Yes.
which actually deals with the point which I was wondering about, as to whether costs of going to court to for a guardianship order under Section 5 of the Children Act,
Yes.
in the event that there was nobody with parental responsibility, that would be covered. That looks as though that's what happened here, or something similar.
My lord, yes.
One of the tribunals in this case noted the reference in the textbook to this case, but said it was unreported, so they had no way of getting hold of it.
Yes, we haven't been able to find it despite our best endeavours. This is the only reference that's been identified. But my lords, the point of this, again, and the reason why I refer to it, is that it provides for analysis of those losses arising from these very unusual circumstances where someone looks after a disabled child, and the authority being able, in my respectful submission, to make an award for those losses, and in particular in this case the adaptations which are necessary because he is disabled, and the court of protection costs that follow from his disability. So you take, put it simply, you take your qualifying claimant as he or she is.
Are the losses in this case, which you're seeking to recover, were they incurred when Dominic was under the age of 18, or after, or both?
My understanding is before he was 18. So the adaptations were
Yeah. The Court of Protection costs would be after 18. wouldn't
yes, they would be. So there'd be up to and after. And his litigation friend is his deputy, so those costs would be fixed.
they? Yes.
If you're right, then capital cost of adapting accommodation is payable if the qualifying child at the time of the adaptation is 17, but not if he's 19.
Yes. I mean, these are costs incurred as a result of him being a qualifying claimant under the age of 18, because as I took you through the scheme, in order to be one of the gateway requirements was being under the age of 18. And those are claims or costs or sums which were incurred under the age of 18.
So how do the Court of Protection costs fall within the scheme?
Well, my lord, I suppose that's where the multiplier comes in, because your lordships, and I'll take your lordships through the actual first decision, but the first decision made by the CICA, which was then subject to the First-tier Tribunal's determination, did award a figure of £16,000 circa for court protection costs. And it's unclear, in my respectful submission, where that figure comes from, other than some internal guidance or a figure that's plucked out of the air. But to answer your question, my lordship, that it will the multiplier used would then give rise to an award beyond the age of 18.
I don't want to drag you down a cul-de-sac,
Yes.
or at least a path which is going to take you out of your stride. But I just wonder whether a court of, if someone, an incapacitated adult will need a deputy in any event,
Yes.
whether or not their parent is still alive. So why is that a loss? Why are the costs resulting from receiving the court protection for the appointment of a deputy recoverable? And there's a difference, it seems to me, between the appointment of a guardian for the child,
Yes.
to replace a parent because there's no one with PR,
Yes.
and the appointment of a deputy, which would arise in any event when the young person had changed the majority because they need if they need a deputy, the parent can't, the relative can't act in that capacity without an order.
Yes.
So I'm, at the moment, for my part, I'm slightly puzzled as to how the Court of Protection costs fit in, but perhaps you'll come back to that.
Could I come back to you?
Yes, I'm just flagging that up.
Yes,
What a
great.
concern I have.
And may I just ask you a
Yes.
question before you leave page 340?
Yes.
Where it says the passage that you rely on, more likely this provision could legitimately be used to permit the authority in less usual cases where the qualifying claimant child was, for example, already very disabled and required extensive care from the deceased parent, now provided by another. That you obviously take the same in tort law, the claimant as you find them, a child with lots of need for care.
Yes.
But that doesn't equate to the need to change the building.
The adaptations, my lord, arise as a result of the disability that the applicant or the appellant has.
Yes, but what the applicant lost when mother died,
Yes.
was someone who was caring for him
Yes.
full time,
Yes.
and obviously with excellent
Yes.
care. Whereas he was the need for the adaptations
Yes.
didn't arise from the death of mother.
Well,
He'd always needed those.
yes, and in my submission, if mother was still here, she would have cared for Dominic in a way which may have included an adaptation to properties to allow for his needs to be met, and in particular his incontinence needs, which gave rise to the necessity to build ground floor bathing or toileting facilities. So they would, in my submission, fall within the definition of parental care in any event.
Thank you.
My lords, I don't want to take you through the sequence of the actual decision making, and going back to the core bundle, if I may. The first decision of relevance is the decision of the authority dated the 11th of January 2016, which is at page 130.
Should we just anchor the story in the chronology of tab 4? Is there any dispute about that? Page 31.
Any dispute? I don't believe there is, no.
Good. Okay, so which page are we going to?
We are going to page 130.
Thank you.
my lords, this is the first decision of the authority after a claim was made, and your lordships will see that an award or compensation was made in the sum of £44,210. And over the page, at page 132, it sets out, and 133, it sets out how that figure is arrived at. And provides some analysis at page 134. And your lordships will see, based on my previous reference, at the bottom of the page, of page 134, is a paragraph which grants an award for the court protection costs. The first-tier tribunal's decision of Judge Beale and McGarr is at page 118 of the core bundle.
We don't have the documents which led to the claim, the award, do we?
You don't, not in the bundle, my lord. No. You have the skeleton arguments before
Yes.
the tribunal, but not the documents.
Not how the was the who put the claim in? Actually put it in for Dominic.
I assume it was his litigation friend, his maternal aunt. But
Yes.
I can-
She wasn't then his litigation
No.
friend,
No.
so was she the deputy?
She may have been the deputy at the time, but I assume she was deputy after the settlement in the compensation claims under the Fatal Accidents Act.
Which followed on, did they?
Yes.
The
Okay.
appellant to the first-tier tribunal is Victoria Tracy.
Yes.
Yes, so she right.
Yes.
Okay.
I can get confirmation, but I assume that
We
is
don't
correct.
we don't have she actually presumably didn't have legal representation at this point.
At the first-tier tribunal,
No,
she did.
before the I'm sorry, forgive me. Putting in the claim to the authority.
I'm not sure is the answer, but I can find out. my
Sorry,
lord.
I'm distracting you.
No,
We
we'll
want to
add
go
it.
to the tribunal, the FTT.
We'll add it to the list, my lord. The FTT decision of Judge Beale and McGrath is at page 118. And at paragraph 3, page 119, it helpfully sets out the decision of 2016 of the authority and how the payments were divided. Paragraph 10 at page 120 also sets out the exact issues before your lordships today, which was the issue before the first-tier tribunal, whether the costs of administrating the trust are compensatable or recoverable as together with the adaptations and extensions. My lords, you will find of relevance page 125 onwards, which sets out the decision. But in particular, prior to the heading of the decision, paragraph 33 is relevant because that's where your lordships will find the need for the adaptations and the extensions arising from Dominic's needs. The relevant paragraphs reaching the relevant decision at the first-tier tribunal is at paragraph 37.
Do we have the costs of the adaptations?
You don't, my lord. In the normal course of events, once the matter of principle was determined at the first-tier tribunal, and so, for instance, if said that they were recoverable, it would then go on to a quantification hearing. Yes, that's why there was such limited evidence. Paragraph 37 and 39 and 38 sets out the First-tier Tribunal's decision. Did not accept the costs of accommodation or the adaptation were losses that were intended to fall within paragraph 42b, and the conclusion being at paragraph 39, and the principal reason that the cost of the extension or indeed the adaptations to the house was not a resultant loss because it did not arise from the loss of parental services.
And also the tribunal disagreed about the quarter protection costs.
Yes, for the same reasons.
Which it held had been paid in error.
Yes, and which the authority at the hearing asked to be reconsidered.
What, at that hearing?
At that hearing.
I'm not sure that's right. Go to paragraph 2. Because they say it falls outside.
Sorry. Paragraph 2.
Sorry,
Page 119.
there was a bit where it said something like, "We're not concerned with this on the appeal."
I think there's paragraph 15, my lord, at page 122, which sets out the respondent's position at that appeal.
Thank you.
My lords, the next decision of relevance is obviously the impugned decision of the Upper Tribunal of the 26th of April 2024, which is at page 32 of London. Insofar as this is helpful, and I don't intend to take your lordship through this, but at paragraph 6 at page 34, the decision sets out the First-tier Tribunal's decision. Paragraph 7, page 40, sets out the 2001 scheme, and paragraph 8, page 42, sets out the 2012 scheme. And the analysis, following detailed submissions, one finds in paragraph 60 onwards at page 53. And paragraph 60 finds that that the correct interpretation importing certain words for paragraph 42b was other resultant losses must mean other resultant losses resulting from the loss of parental services. The reference of paragraph 61 to the word other or other payments or other resultant losses being construed in context of the paragraph as a whole. The conclusion, my lords, you will find at paragraph 66, page 54, and paragraph 67. If I could just ask your lordships to read those two paragraphs. On the second ground, the analysis commences at page 71, page 55, sorry, paragraph 71. And the conclusion at 71 that the costs of adaptations fall beyond the ambit of paragraph 42b, and the rationale at paragraph 72 that it cannot be categorised as a cost to replace the care of the applicant by his mother. And the same point, my lords, made paragraph 73 on page 56. Miss Gander will consider the third ground, but what follows after that analysis, my lords, is something with respect slightly unusual insofar as that Upper Tribunal Judge West then goes on to consider the 2012 scheme at paragraph 83 onwards at page 57. And refers to the highlights that I've taken your lordships through in terms of the change of wording in respect to the 2012 scheme insofar as it now says as a direct result of the loss of parental services, and you'll see that, my lords, at paragraph 88, page 60. And some analysis at page 89 as to a bit of a confusion as to why the wording was changed in 2011 and why it was necessary to change it in a way which is then found at paragraph 65b of the 2011 scheme. And it's right that I refer your lordships to paragraph 91 at page 61, which is that even though Upper Tribunal Judge West considered the 2011 scheme and didn't find any reasons as to why there was a change of wording, so ergo it must have been the same intention, goes on to say that I've reached my conclusion about the effect of the 2001 scheme without recourse to the 2012 scheme, which in my submission, broadly, I would suggest that his decision-making has been infected in a way by considering the analysis of the 2012 scheme, which post-dated the 2011 scheme, and failed to take into account the 2008 scheme, which I've taken your lordships through, which adopts the same wording as the 2001 scheme. My lords, against that background, my legal submissions are quite simple, if I can put it that way. Perhaps your lordships may disagree, but in respect of the 2001 scheme, which I've taken your lordships through, and perhaps based on my submissions, it may be necessary to bring that up again in the authorities bundle at page 198. But when one looks at paragraph 42, when one considers the qualifying requirements, using that word hesitantly because qualifying claimant is used, but looking at the qualifying requirements, plainly the appellant is a qualifying claimant, if that's accepted. Plainly he is under the age of 18 at the relevant time, and plainly he was dependent on his parent before the index event. Paragraph 42A at page 207 is not in dispute. It's other such payments as the claim officer considers reasonable to meet other resultant losses. And as set out in the skeleton argument, I hope clearly, the appellant argues that when the scheme refers to other, it must be something other than what is set out in paragraph 42A, which is that tariff award for parental services.
The easy bit.
Yes,
That's the first other.
yes. That's the first other such payments. And then there's the other, or the additional other, which is to meet resultant losses. Now, in my respectful submission, the word resultant losses, adopting an ordinary interpretation, provides for, as in this case, you finding the qualifying claimant as you find them, which is that Dominic is a disabled child. He requires his needs to be met and services to be provided to meet those needs under the care.
What is resultant qualifying? Resulting from what, do you say?
Resulting from the incident that gave rise to the application for the award. So had it not been for that index incident, he would have been cared for by his mother. His needs would have been met, and his mother would, in all likelihood, have been his property and affairs deputy.
When you say the incident, do you mean the death of the parent?
Yes.
Can I just ask you in relation to, I appreciate Ms. Candace dealing with this bit, so I hope not to trespass on her ground.
Of course.
But other resulting losses, one wouldn't normally expect in a personal injury context, when you are just looking at causation of losses, to pay for adaptations which were necessary because of the disabilities he suffered from his birth. And those were not caused by the death of the mother, those were caused by the fact he had a disability.
Yes, yes. I don't go beyond that proposition, my lord. But the point I make is that even if one considers parental services, and this is going to my second alternative argument, is that even if Upper Tribunal Judge West was right to import the wording of the 2012 scheme, which is that other resultant losses from the loss of parental services, what the appellant claims for, the adaptations and the court of protection costs, are parental services. Because those are services which his mother would have provided. Now, my lord, your analysis in respect of personal injury proceedings, if the tortfeasor, in my respectful submission, had caused the disability, then of course those adaptations would be part of the claim. But I can't envisage a situation where that is not the case, and you'd be able to claim for adaptations. But these are circumstances in which the purpose of the scheme and the Act is to compensate victims as a result of an act of crime. Now, as I took your lordships through, the scheme provides for, in other circumstances, if you are still alive, for the possibility of compensation or an award to be made for loss of earnings, but that includes, as I've set out, paragraph 35 of the scheme at page 206, the possibility of adaptations, very specifically adaptations to the applicant's accommodation and the cost of the court of protection. So the scheme directly contemplates a scenario that if you are injured as a result of a criminal activity, and that injury gives rise to circumstances which requires your property to be adapted and requires the necessity of court protection proceedings because you lack capacity and you need a deputy, that is recoverable.
But that's because you've lost your arm and you now need some adaptation to the property to enable you to get around it.
Yes.
Whereas this is the loss of the mother.
This is and that is, if I can put it in this way, it is like the loss of the arm, because his mother would have provided him the care because of his disability to care for his needs, which encapsulates the need for adaptations to his property and encapsulates the need for court protection proceedings. Otherwise, in my respectful submission, in the scheme, it would not have allowed for, under paragraph 2, the possibility of multipliers to consider the individual circumstances of a qualifying claimant. And that reference is at page 208, first paragraph.
Thank you.
If the authority, when I say the authority, the criminal injuries authority is right in its interpretation that it doesn't fall into the remit, then the scheme in itself results in a scenario that if you are a disabled child, a qualifying claimant, then all you're permitted to claim for under this scheme is the tariff award. And if there are any costs associated with, or detailed costs associated with adaptations or court protection costs, all things which arise from the disability, which would have been provided by the parent, then those are not recoverable, which in my respectful submission goes outside the ambit of what Parliament intended by way of the scheme. My lords, that's my first ground. My second ground is that even if you're not with me on that point, and I should say that the references that I took your lordships through in Begley first edition and second edition provide and support for the analysis that I said. But even if you're not with me on the first ground, and Upper Tribunal Judge West was right to import the words resulting from parental services, and I make the same point, these are parental services. These are services which would have been rendered by the mother had the criminal activity or the criminal act not occurred.
Can I come back to the court of protection point? Given that court of protection proceedings would have been required in any event,
Yes.
how can the cost of those proceedings be said to result from the death of the mother?
My lord, the same point, which is that whilst it is part of the parental services that she would have provided had he been in receipt of any type of compensation, or, for instance, if he was in receipt of benefits from the Department of Work and Pensions, albeit she probably would have been his appointee in those circumstances. But they are consequence of, they follow, in my respectful submission, the causal nexus of the criminal activity, something that she would have provided under parental services, and a result where, by reason of the criminal activity, those services are now being provided by the aunt.
Well, when you say she would have provided, I mean, maybe is Miss Scanner dealing with this point? I'm not quite clear, but do say if she is. But if not, can I ask you this? When you say she would have provided
Yes.
the cost of the court of protection costs, what do you mean?
My lord, if she would have provided.
Well, you're saying that this is a loss attributable to her death,
Yes.
mother's death,
Yes.
because she would have paid for the court of protection proceedings?
Well, the court of protection proceedings arise by way of the compensation, or by reason of the compensation, I assume, albeit he might have been in receipt of benefits which may have given rise to him having a deputy for which his mother would have provided. So I say that his mother would have managed his property. And
So there's only property to be managed, is what you're saying, because of the compensation?
or his benefits. So he would have been in receipt of benefits.
He would have been in receipt of benefits even if his mother had lived?
Yes. Yes.
So there would have been the necessity for court of protection proceedings.
Possibly, my lord, yes.
So why did the cost of those proceedings result from his mother's death?
I think this... Sorry, my lord, just one second.
Is Miss Scanner going to deal with it? If she is, then park that point, Mr. Kerry,
Yes.
and come back to it.
I'm grateful. My lords, when I said that the legal submissions were simplistic, they are that simplistic. It's considering the ordinary meaning of what the scheme provided for under paragraph 42. The first ground, as I've articulated, is in respect of the material error that Upper Tribunal judge came to in importing the words from the 2012 scheme. That's something which I suggest and assert he should not have done when the 2001 scheme was absolutely clear in its terms. And even if he was right to import those terms into the 2012 scheme, the wording permits, in my respectful submission, those two claims of losses to result in an award under paragraph 42. To do otherwise, in my respectful submission, would be inconsistent to the purpose of the scheme and would provide for this qualifying claimant to be in a position which is not comparable to the position of an individual who has been injured and can seek special expenses by way of adaptations and court of protection proceedings. Unless I can assist my lords in respect of 1 and 2.
Right.
I'll hand over to Ms. Gander.
Over to Ms. Gander. Yes, Ms. Gander. It's good to have a case in which junior counsel is taking an active part.
Great.
Doesn't mean to say all right, but it's good.
My lord, so you content me to deal directly with ground 3, or would you rather?
Whichever you prefer.
I'm grateful. I may start with ground 3,
Yes.
if I can, thank you. By way of overview, this ground is directed to the definition of adaptation to accommodation. And if I could invite your lordships, please, to turn to page 126 in the core bundle. And at paragraph 39 of the first tier's written reasons, we see their treatment of adaptation to accommodation. If I could invite your lordships, please, to note within that paragraph the following words. The recovery of the cost of an extension would be significantly widening the remit of the scheme. And they go on to say it is of note that whilst paragraph 35 allows the reasonable cost of adaptations to the appellant's accommodation, it does not include the cost of an extension. Paragraph 35 in the 2001 scheme is of course a special expense for direct victims of crimes of violence. In essence then, we can say that the First-tier Tribunal found that extension is widening the remit of the scheme, but paragraph 35 is not applicable. The substance of the ground is quite simple. It's set out at page 103 to 104 in the core bundle. And at paragraphs 45 to 49. And we are dealing with dictionary definitions, somewhat, one might say, of an English comprehension test. We say one ought to use, and I understand it's agreed with a learned friend, the ordinary national meaning of words, and for that reason we've used dictionary definitions. And we say there adapt is to make suitable for a new purpose or use, or adapt to make or become suited to different circumstances. And so in the ordinary national meaning of the words adaptation to accommodation, one can envisage, we say, that somebody may have an extension built on their home.
Any extension will be an adaptation, but not all adaptations. No. Is that right? Some extensions will be adaptations. I'm trying to think of it putting in an aphorism. All extensions will be adaptations, but some extensions will go beyond adaptations. Would that be a way of putting it? So, insofar as a house is extended in part because of, say, someone like Dominic's needs, that part of the extension would be an adaptation.
Yes.
But if it included an extensive conservatory, etc., which was not required for Dominic, it would not be included as an adaptation.
It wouldn't, but that would be not because it's not in ordinary language an adaptation to the accommodation, but that would be because it's not a reasonably incurred cost, and there it would be caught by
Well,
paragraph 42.
yeah, it's down to the assessment as to what is and is not resultant from the death of the parent.
Yes, and reasonable in addition. But what's of concern, we say, is that the First-tier Tribunal appear to be looking at adaptation to accommodation in such a narrow way. And I will deal with that just very briefly in terms of the status of this ground, because if the appellant were to succeed on grounds 1 and 2, then this ground remains material, because as it stands, there is a decision from the First-tier Tribunal that hasn't had any treatment from the appellant courts yet, to say that an extension, reasonable or not to be investigated on the next occasion, that an extension simply as it is widening the remit and cannot be caught within a definition of accommodation, adaptation to accommodation. And so we do invite your lordships to consider that point in principle if the appellant succeeds on grounds 1 and 2, 1 or 2 I should say. But if the appellant doesn't succeed on grounds 1 or 2, we say that this ground still remains significant. We say it's of public importance, and we would invite your lordships to pass any observations that you consider fit. The reason we say it's of public importance is because, firstly, adaptation to accommodation is a term that has been retained from the 1996 scheme through to the 2012 scheme. So an applicant making an application today or having their case heard today will grapple with this.
A direct victim.
A direct victim, forgive me, yes, under paragraph 35 as it was in the 96, 2008 and 2001 scheme. And if your lordships would like to mark or turn those pages up, they are in the authority bundle at page 226, 246 and 206 respectively.
Sorry, 226, 246.
And 206 respectively.
May I just ask, just to ensure that I got the shape of this point? The First-tier Tribunal wrongly used the wording from direct victim. You rely on the points which Mr. Carring has made to show that you're entitled to the adaptation and accommodation anyway. but in any event, you would ask us to look at this because you say this might affect direct victims in the future.
Absolutely.
All right,
Yeah,
thank you.
Yes, I would. And in the 2012 scheme, for your reference, it's become paragraph 53D, and that's at page 274 of the authorities bundle. And you will note when reviewing the special expenses permitted across the several schemes that there are few special expenses that are allowed, and this is one of them. We also submit that those applicants that come before the first-tier tribunal, having had to incur the expense of building an extension, are likely to be the most seriously injured direct victims. Those are individuals who evidently will be unable to navigate parts of their home, or who will require downstairs toileting and washing facilities.
Has there been any case law on paragraph 35?
My lord, I have looked extensively and I have been unable to find any case law on it being interpreted on this particular point as to adaptations and extensions, etc. There is some discussion that I have found, it's not within the bundle, as to whether one would be able to claim for leaving the home if one needs an entirely new property, and that's been the discussion. There's nothing on this point.
That's a different point.
Yes, it is, precisely.
But I can see that this is an important point. So you say even if this appellant loses to, you want us to say, had it been necessary, looking at this paragraph in the FTT position, we wouldn't have agreed with it or something like that.
Yes.
Yes.
Thank you. My lord, just briefly, one of the reasons that sits behind that is that terms of art ought to be avoided when the layperson is meant to be able to navigate the scheme, and that's why we bring it to your attention in this way, the concern for those lay individuals.
Yes.
My lord, that is round three in essence.
Now go back to the point that Mr. Kerry left for you.
Yes. My lord, may I just have 1 moment,
Of course.
just to check? My lord, in respect of the question as to the Court of Protection costs, it's right, of course, that the appellant already had a need for Court of Protection's involvement and already had a deputy. The issue here is quite a discreet one, and it's this, that in receiving the award from the CICA, obviously depending upon the amount of the award, it's likely that there would be additional costs in managing that fund if the fund grows and perhaps needs to be managed more. And so any reasonable fees, and again 42B allows for that gatekeeping effect, that it's any reasonable fees caused by having to manage the CICA's award. In the same way that one may have a direct victim of a crime of violence who lacks capacity in any event, but is, as we understand it, entitled to Court of Protection costs as a special expense.
Sorry, a disabled, someone who is disabled prior to being in direct victim. Is that your point?
Yes, my lord. May I just pull up the?
So we're looking at 35 then, are we?
Yes.
Are we in subparagraph D?
Yes. My lord, forgive me, may I just check that I'm in the right scheme? Yes, so page 206.
Yes.
At paragraph 35, 4.
D4.
Apologies, yes, 35D4. The cost of the court of protection or of the curator.
That's the Scottish equivalent.
Yes. And there lies, we say, the internal unfairness. One can be a direct victim and have the funds available to manage the CICA award, but one can be arguably one of the most vulnerable applicants to require the scheme's assistance, which is a dependent child who has lost a parent due to a crime of violence and not have funds available to manage the award. And it's those additional funds to manage the award that would be reasonably incurred.
So any additional costs incurred in the court of protection over and above what would have been paid anyway,
Yes.
insofar as the additional costs were attributable to the death of the parent.
To the management of the
I see.
award.
I see.
Can I just ask you about 35D? I mean, that applies for a person who perhaps had capacity beforehand, but because of the attack no longer has capacity and then can get the court of protection. It doesn't deal with a person who didn't have capacity, was always incurring those costs and was then going to have the court of protection anyway.
Well, my lord, it doesn't state, we say, either way. It simply states the reasonable cost of the court of protection costs. It doesn't specify that it has that aspect must be attributable. And in fact, if one looks,
We then get into the interpretation of the first 3 lines of paragraph 35, which I've got your point. Thank you.
thank you, my lord. May I insist just very briefly on the first 3 lines of paragraph 35, which is an eligibility gateway. One has to have suffered that level of loss of earnings to then be entitled to the special damages or special expenses that flow.
Or if not normally employed, incapacitated to a similar extent.
Yes. There is provision in the 2001 scheme. May I just take a moment before I take you to it? well, just on this point, just invite you to note how it stands at the moment in respect to the 2012 scheme, because these are questions of public importance as opposed to those questions directly applicable in this case. And if I could invite you please to turn to page 285 in the authorities bundle, 285. Because this is probably the best example.
Yes, which
And it's
paragraph?
106 and 107. And here we can see, and this is very similar to paragraph 15 of the 2001 scheme, that the claims officer may give directions, impose conditions, and make other arrangements. And at paragraph 107, that if the cost is relatable to paragraph 52I, which is a trust, setting up a trust, then that would be covered by the authority. And it's of note, I simply draw it to your attention that it's described as a cost. And that may have one may be able to take some assistance then from whether paragraph 35 must be directly, the need for a COP, for instance, to be or a trust to be directly caused by the crime of violence, or whether if one is injured in crime of violence as a direct victim and one already lacks capacity and one is about to, for instance, have an award of £400,000 or £500,000, the additional costs and the additional fees required to manage that award ought to be, we say, recoverable for that direct victim. Otherwise, one is effectively, not to put it too highly, but discriminating against those who lack capacity, because the amount that they will be able to keep from their award will be diminished by the fact that they need to incur additional fees. I don't anticipate I can put it any further than that.
Very much, Stanley. Mr. Ray.
Thank you, Lords. I don't think that I can improve on the helpful chronology that my learned friend took the court through, so I wasn't intending to go back through all of the stages that this claims process and appeals process has taken to lead us to today, but rather to restrict my submissions to responding to particular matters that have been raised by my learned friend submissions today. If I could take your lordships first of all to page 127 of the authorities bundle.
127.
127.
Thank you.
So this is the guide to the 2001 scheme that your lordships were asked to look at as part of my learned friend submissions in relation to ground 1.
Yes.
My submission on this point is a short one, and that is that in this version of the guide, as with the later version of the guide, as with the extracts from Begley, all of the commentary relating to other resultant losses falls under a heading, And that heading is, as we see on page 127, in bold and underlined, of loss of parental services. In my submission, there is nothing confusing in the guide for a potential applicant in understanding that the awards that can be made under the scheme in respect of paragraphs 42A and 42B both relate to the loss of parental services. That is clearly highlighted by the use of that heading in the guide, and it is also, in my submission, clear on the face of the wording in paragraph 13. That says that a qualifying claimant under 18 years of age may be eligible, in addition to any sum for dependency, for compensation for loss of parental services at an annual rate of level 5 of the tariff, currently £2,000. Compensation may also be payable to meet other resultant losses, e.g. any additional cost of childcare or loss of earnings suffered by an adult in looking after the child. An appropriate multiplier applied to the period until the child reaches the age of 18 will be used. And my lords, if we turn to paragraph 42, which is 207 of the Authorities Bundle, the paragraph starts at the very bottom of 207 but continues to the top paragraph of 208.
Yeah.
And it's that top paragraph to which I would direct your lordship's attention, because that does say that each of these payments will be multiplied by an appropriate multiplier. It does not say if the payment for other resulting losses is in respect of an ongoing loss of parental services, it will be subject to a multiplier, but if it is a one-off payment for a special expense, it won't. It is prescriptive and clear in the language, and that fits with what my primary submission is, my lords, which is that the language of paragraph 42 taken as a whole is extremely straightforward and clear, that both paragraphs A and B relate to losses for loss of parental services.
Are you saying one-off payments can't be covered?
Yes, my lord, I am, because that is the clear implication of the use of a multiplier multiplicative approach. It cannot be used with a one-off sum.
But it only has to be multiplied by an appropriate multiplier, and if it's a one-off payment, no multiplier would be appropriate. It could be said.
Yes, my lord. I don't want to over-egg my position on it. I cannot see myself, having thought about it, what one-off cost could fit from the loss of the care provided by a mother or father for a child, but I should not go so far as to say that one doesn't exist, that I haven't thought.
Well, what do you say to the one I put to Mr. Kareem, which is assume there's nobody with parental responsibility left. The father's position is complicated, which would involve various aspects of children's law we needn't worry about, but forgetting the father, assume nobody's left with PR, and therefore there has to be a guardian appointed, which means a guardianship application to the court under Section 5 of the Children Act. That would be a one-off payment. Why would that not be covered?
That would not be covered, my lord, because it is not a loss suffered by the child. That is a loss incurred by the prospective guardian or the local authority. So in my submission, paragraph 42 is about the losses that the child suffers, the loss of their parent, the loss of the services provided by their parent. Their parent wouldn't have paid for that service because that is not something that their parent would have ever needed to do. So on that basis, I would say that it wouldn't fall within paragraph 42. But if you're not with me on that, and I understand from the Begley reference that there has been an unreported case where such a sum was recovered, then that would be an example of a rare one-off payment that could be made for another resultant loss.
You challenge, but you don't accept Mr. Kareem's submission that the resultant means resulting in the death of the parent.
No, my lord, I don't. I say that it results from the loss of parental services, that is in accordance with the natural and ordinary meaning of the language within paragraph 42, when read as a whole, it's also entirely consistent with the guidance that we've been referred to and the commentary, where the entire discussion is about the loss of the care of the applicant by the parent. Ordinarily, in the ordinary scheme of things, where there is a qualifying claimant, they are inevitably a child, so they are under the age of 18 years, and they are assumed to have lost the care and love and support of their parent if their parent dies as a result of a crime of violence, and they get, as a result of that, under paragraph 42A, a tariff award. That is a blunt instrument. It is £2,000 a year to the age of 18, and the only way in which that can be adjusted is by virtue of the multiplier in relation to the final paragraph of paragraph 42 at the top of 208. There is no discretion there. The amount is set. It's £2,000 per year till the child turns 18. Paragraph 42B allows for the possibility that there are reasons to depart from that tariff award in particular circumstances, and the examples given are where there are onerous requirements for
Disabled child, a disabled child.
For a disabled child. There could be other examples. I think you could see, for example, a newborn baby where you required a wet nurse, for example, would be possibly a reason to depart from a mere tariff award. And the tariff award itself inevitably leads to older, more independent children gaining more of a benefit than younger, more dependent children from the loss of parent services, because it's flat. It doesn't decrease over time. And that is in the nature of the scheme and the way that tariff awards work.
Your interpretation would be obviously right, were the phrase in 42B, such other payments as a claim officer considers reasonable to meet the loss of that parent's services. But the phrase uses resultant losses.
Indeed, my lord, it is, and that is the phrase that was used all the way through until the 2012 scheme language was updated to make that explicit in my submission. But what that means is nonetheless, in my submission, clear on a straightforward reading of paragraph 42. The other resultant losses result from the loss of parental services. The entire paragraph is about parental services. There are other paragraphs that deal with other types of loss. So they deal with dependency, they deal with a bereavement payment, and it is only the types of loss that are explicitly set out in the scheme that are recoverable. So because,
Sorry to interrupt. Just on your submission on the qualification of the proviso to 42A and B, each of these payments will be multiplied by an appropriate multiplier. If you have someone who's 17, they cease to be eligible at 18, is that right?
yes,
So if you had someone who was only going to have losses for 1 year, your submission would then be, well, that's not caught because it's never going to be multiplied by an appropriate multiplier, or do you need to modify your submission?
I need to modify my submission, my lord. It's an appropriate multiplier in precisely the same way it would be for a loss of earnings type claim, where if there is a year or less, you can nonetheless calculate a multiplier. It represents the period of time until the child turns 18, and there is always going to be an appropriate multiplier, whether that is more than or less than 1.
Thank you.
I do find it strange. Each of these payments, you say, refers to all payments under 42A and B, but A are annual or monthly payments anyway.
Apologies, my lord, I didn't quite hear.
A payment for loss of that parent's services at an annual rate of level 5 of the tariff. I suppose if that's multiplied, that's to make a capital sum. Because you don't do periodical payments. All right. Then you say such other payments as a claims officer considers reasonable to meet other resultant losses. you say that can't be one-off payments because they're capable of having a multiplier applied. Then why not just say such other annual payments or regular payments?
My lord, in my submission, the way that the provision is drafted links the concepts together so that it can be understood to say, if you have lost the care of a parent through a crime of violence, it is assumed that you've lost something of value, and that is your tariff award, £2,000. But if, in the particular circumstances of any given case, there is some other loss because of the particular care that that parent was providing to that particular child, then, provided that it is reasonable to compensate the child for that loss, a claims officer can make another payment to reflect that additional level of loss over and above the tariff award, which then needs to be subject to the appropriate multiplier to reflect, in the same way, the period of time that the claimant is eligible to receive the payment for.
The multiplier isn't the same, is it, under A or B? The multiplier may vary.
Indeed, my lord,
It's the
it may.
appropriate multiplier.
And there may be more than one other payment under B.
Yes.
So, there
So
could be
under B,
multiple-
there could be different types of payment
Indeed,
in respect of different multipliers.
yes.
Why shouldn't one of the multipliers be 1?
Indeed, my lord, I accept that it can be one. My submission in relation to it not applying to one-off payments is not that the multiplier cannot be 1 if it respects a year. It's that it relates to a period of time over which the loss is incurred, as opposed to the purchasing of equipment or the costs in this case of an adaptation or extension. It may well be, if we take the example of a newborn, that it would be appropriate that there may be provision for a wet nurse for a year or 18 months.
Right.
If the child was severely disabled, there may then be provision of an additional payment to reflect additional parental care provision over certain years of the child's life. And there's nothing within the rule that prevents multiple payments with different multipliers being made where it's reasonable to do so, because there is a loss of particular parental services that apply between that parent and that child. My lord, just in relation to one matter that was raised in questions to my learned friend, if I could ask you to turn to the First-tier Tribunal decision at page 119 of the core bundle. Apologies, that's the beginning of the First-tier Tribunal decision. It's paragraph 41 at page 126 that I'm just looking to refer to. Just to clarify in relation to paragraph 41, the position in relation to the court of protective costs that had already been paid, the point of principle was litigated with the First-tier Tribunal, but there was no attempt by the CICA to seek to recover that money.
Yeah, I should
And
hope not.
it remains not an issue. There's no seeking to recover it. It's simply a point of principle.
So it was an issue, but only for the legal purpose.
Yes, it was an issue in the sense that what the correct interpretation of paragraph 42 meant included a discussion of sort of protection costs, but it wasn't an issue in terms of any order being sought in respect of what had already been paid.
Why do you say we're going to come on to do with trust costs?
Indeed, Lord, I'm happy to deal with that point now. if it
Don't
would
take
be
you out of time, sorry.
Of assistance. My Lord, I'm happy to reiterate my submissions in relation to why I say that the interpretation of paragraph 42 is as the CICA, First-tier Tribunal and the Upper-tier Tribunal have found it to be. But I'm not sure that there is much I can usefully add to the written submissions that I've already put in. So if I can turn then to the second point in issue in this appeal, which is if that interpretation is correct, then does the cost of an adaptation or extension and the cost of court of protection and trust costs fall within that definition? And again, my submission, very much mirroring the view taken by the Upper Tribunal and the First-tier Tribunal, but predominantly the Upper Tribunal, is that taking a common sense approach, what is a loss of parental services? It is the loss of the care of the child by their parents. That is the loss that is being compensated by paragraph 42. It is something that this scheme provides for, and it is limited to the two types of payment that paragraph 42 provides can be made. I've set out in my submissions the prescriptive nature of the scheme, and in my submission the attempt to look to paragraph 35 in respect of a directly injured applicant is impermissible. However, given that much debate has been had about paragraph 35, I would like to respond with some submissions in relation to that. If I could ask you to please turn to page 206 in the authorities bundle. Well, I know that the point has already been noted, but it is the stem of paragraph 35 that I would draw your attention to, and in particular that paragraph 35 applies where the applicant has lost earnings or earning capacity for longer than 28 weeks as a direct consequence of the injury, other than injury leading to his death, and that applies whether the person was employed with lost earnings or they were similarly incapacitated but have not already been employed. That is, in my submission, a qualification to the availability of any of the heads of loss in paragraph 35.
What phrase particularly qualifies everything?
As a direct consequence of the injury. So in my submission, a direct victim of crime, even a direct victim of crime who is themselves a severely disabled child, cannot, under paragraph 35, seek payment for special equipment that they already needed due to their pre-existing disability. And to suggest that there is a broader scope of compensation for a fatal's applicant than a directly injured applicant, in my submission, is not premised upon anything that we find within the scheme and is contrary to the obvious intention and thrust of the legislation. There is no reason why a child applicant under paragraph 42 ought to be in a better position than a direct victim of crime dealing with paragraph 35 entitlement. So I do say that even if we were looking at the items of loss that can potentially be recoverable in paragraph 35, they would not be recoverable if the need for them arose not from the crime, but from the pre-existing disability of the applicant. And that is true also in the 2012 scheme to which you were referred. Bear with me, I'm just checking the page reference.
There's a big, striking distinction between 35 and 42. 35 is anything directly consequential on the injury, but it's very clearly defined. The heads of loss are clearly defined. There's no catch-all, any other loss considered reasonable resulting from the death, resulting from the injury. Is there?
No,
It's
that's
all defined.
it's entirely
Got that right?
correct.
Whereas 42 has the tariff, and then this other much broader, more flexible, discretionary phrase, such payments as the claims officer considers reasonable to meet other resultant losses.
Indeed, my lords, and were a loss resultant from the loss of parental services, I do say that paragraph 42b is broad. It is flexible. It does allow for just awards to be made within the confines of the scheme, but only in respect of the loss of parental services, because that is what the stem of paragraph 42 tells us paragraph 42 is compensating for, not any and all costs arising in relation to the applicant.
Then 42 can't be viewed in isolation, can it? Because the earlier paragraphs are part of what can be claimed.
Indeed, my lord, yes. The paragraph 42 is a specific provision that deals with loss of parental services, which has obviously been the focus of the intense scrutiny in all of our submissions, but it is only part of a suite of provisions in the 2001 scheme that apply in fatal cases that starts at the top of 207, and that deals with all of the matters that are available as compensation to victims in those circumstances. Or rather, I should say applicants related to victims in those circumstances. It is not the only provision that provides compensation, and of course, one of the most significant ones will be the provision under paragraph 40 and 41 in respect of dependency. The financial losses and costs, and indeed cost of care, are dealt with in relation to dependency claims in paragraph 41. Paragraph 42 is a specific additional head of loss that's available under the scheme in my submission solely related to the loss of parental services.
The cost of care expressly said under 41 to be calculated on a basis similar to let's call it an own injury case under 35D3.
Indeed.
Yes.
And of course, you could argue where care has been provided by parent, well, that could potentially fall under paragraph 42b, but of course it doesn't, because it is explicit in 41 that of course care is dealt with as part of the dependency claim under well-known and well-understood principles. My lords, you were taken to the 2012 scheme just for completeness. I think you were taken to page 285 in relation to the ability to make payment of trust costs if the trust has been directed by the CICA in paragraphs 106 and 107. And that refers back to paragraph 52I of that scheme, which is at page 274. So that is part of paragraph 52, which is the list of special expenses. But paragraph 52 is part of a section of the 2012 guide that starts at paragraph 50 under the heading Special Expenses Payments, and paragraph 50 explicitly states that an applicant who is eligible for an injury payment will be eligible for a special expenses payment if, as a direct result of an injury for which they are eligible for an injury payment, they have lost earnings or earning capacity or been incapacitated to a similar extent for more than 28 weeks. So it's the same in substance, although the wording is slightly different. And it is absolutely clear that under the 2012 scheme, as well as under the 2001 scheme, there is still very much a requirement for a direct causal relationship between the injury to a directly injured applicant and their ability to claim a special expenses payment, and indeed then of course any trust payments associated with trust that's been directed in accordance with provisions made under the grants. So it is no support at all for the suggestion that there is provision for the CICA within the scheme to pay additional trust fees where there is no direction by the CICA for trust in the first place, or a direct causal connection between the injury and the need for that trust to be set up.
All parental services would be covered by 42 that were not cost of care under 41.
Well, my lord, something like love and affection is covered by the tariff award, so you can't claim that as care costs because it can't be quantified. But the loss of a mother or father, providing that, let's say, invaluable support, emotional care, something that does not qualify as a care need. There doesn't need to be an injury to the child. There doesn't need to be a disability to the child to have lost the benefit of parental services, of providing their food, taking them to and from school, looking after them, being available to watch them overnight. All of those things that make up parental care that are not dependent on any injury or care needs on behalf of the child, save for the fact that they are a child.
Well, some of those would be practical matters that would be covered by cost of care, but some of those are impractical matters. This is what you're saying, nebulous matters like emotional care, obviously crucial for a parent to give.
Indeed.
So that's what the tariff is designed.
That's what the tariff is designed to do in a general and blunt manner.
Yes. You're saying that resultant loss means resultant to the loss, to that loss as well. So we're talking about that sort of nebulous loss of parental service. And the claims officer's got to consider, has there been any other resultant loss?
Indeed.
If you're right.
So a classic example that's given in all of the guides is childcare. So the care provided by the parent to the child is not being paid for. That is simply the provision of parental services. If that parent dies and someone else has to provide that childcare at a paid rate, or has to quit a paid job in order to provide that childcare, that is a loss resulting from the loss of parental services. And that is something that is envisaged by 42.
Why isn't that covered by as cost of care under 35, under 41? So cost of care is the basic compensation, is part of the basic compensation under 41, as the Lord has pointed out. 42 is about additional compensation over and above the cost of care. It includes parental services, tariff figure. You say 42B is other payments to meet losses resulting from the loss of parental services.
Indeed, my lord, yes. So I may need to turn my back to double check my understanding of this, but
Please do.
my understanding, I have an understanding.
Yes.
you. I'm grateful, my lord. The answer is it can and does get dealt with under both, depending upon the way the claim is presented. So an example of somebody hiring in a nanny will more likely be dealt with as a cost of care claim, whereas the provision of occasional assistance in respect of someone collecting a child from school may more likely be an additional payment under 42B. But there isn't a firm dividing the line from the perspective of the agency as whether something must be dealt with one way or the other.
Take a very simple type of case. Old-fashioned household, a young child. Dad goes out to work during the day. Mum, while the child is very young, stays at home, looks after the child. Mum is then murdered, not by Dad, but by a third party. Dad keeps going to work, but gets in professional nanny or carer all day. That seems to me in any proper scheme must be covered. You say it could be probably 41, although it could be 42, but anyway it's covered.
Indeed.
Yes.
I think I've really covered in the course of those submissions both aspects of that second ground in relation to whether either adaptation or accommodation or protection costs would fall within it, simply because we say it's care provided by a parent to a child and neither thing falls within that definition. If I can then turn to the third ground, which is in relation to adaptation versus extension, if I put it that way. My lords, if I could take you back to 119, which is the in the core bundle.
Yes.
So it's the first-tier tribunal decision. If we turn through it to the next page, so 120, the issues are set out at paragraphs 8, 9 and 10, and in particular paragraph 10, subparagraphs 1 and 2. And there are two points to note. The first is that the issues to be decided by this hearing is paragraph 9, where the interpretation of paragraphs 41 and 42 of the scheme and the heads of loss recoverable thereunder. Obviously nothing's arisen further on appeal in relation to paragraph 41, but paragraph 42 is now the subject. There is no reference to paragraph 35 of the scheme, and then paragraph 10 breaks that down further, in particular, number 1, whether the costs of administering the trust of any award and protection costs were compensable, and 10.2, whether the costs of adaptation or extension to Mrs. Treacy's house were recoverable. Paragraph 11 makes it even more explicit the tribunal was only concerned at this hearing with determining whether those heads of loss could be compensated under paragraphs 41 and 42, and not with determining the quantum of any such compensation. And then it goes on to set out the relevant paragraph. So the position of the CICA is simply that the first-tier tribunal gives no determination on the interpretation of paragraph 35, because it is not a decision made under that paragraph at all, and that is explicit on the face of it. So there is no risk in relation to the offending comments that my learned friends have highlighted in respect to paragraph 35, where there are, I accept, at paragraph 39 of the first-tier tribunal judgment, which is page 126.
Yes.
There are some comments which the first-tier tribunal went on to make about whether an extension is envisaged as part of the scheme as a whole, a recoverable loss, which go beyond the ambit of the issues that the First-tier Tribunal was seized with determining. The reason, I think it is clear, the reason why they've done that is as part of their overview in considering the legislation as a whole. But I accept that it's not the most thought out comment in relation to paragraph 35. It's not the position of the CICA that in a case where paragraph 35 does apply and there is a direct injury that results in a need for adaptation, that adaptation cannot include extension, and if it does, then that excludes it from paragraph 35. I don't think that that is what the First-tier Tribunal was saying in paragraph 39. I think it's implicit that what they meant was a mere extension wouldn't come under paragraph 35 if it wasn't for the purposes of adaptation for a need that directly arose as a consequence of the injury. But I accept that they're not particularly clear comments. If your lordships are concerned, notwithstanding the very explicit limitation of the First-tier Tribunal's decision as being only in relation to the interpretation of paragraphs 41 and 42, that it does run the risk of unduly affecting other cases, although given that this is a legacy scheme, I'm told that there are 12 remaining cases in relation to the 2001 scheme in total. It is a
Can I
matter.
just-
Sorry.
Oh, sorry to interrupt. I thought. Can I just? Did the Upper Tribunal say anything about this paragraph?
Yes, the Upper Tribunal simply said that paragraph 35 was of no relevance to the determination, and it made no difference because an adaptation, the basis of paragraph 39 is that whether it's an adaptation or an extension, neither one is provision of forensic services.
Right,
That's the basis of the decision.
I understand that, and you say, and I think Mr. Kareem and Skander accept that if they lose on grounds 1 and 2, this doesn't alter the result. But speaking for myself, it seems to me that that sentence in paragraph 39 of the FTP decision is highly questionable.
Indeed,
It
my
depends
submission
on
is-
what's reasonable, doesn't it?
Indeed, and it's a fact-specific inquiry in any given case. The mere fact that someone has done an extension doesn't make it an adaptation recoverable under paragraph 35, and it doesn't make it not recoverable under paragraph 35. It's neither here nor there. But if it's an extension that doesn't amount to an adaptation, then obviously it would fall outside of paragraph 35. But that is a fact-specific decision that would have to be made by the CICA and then First-tier Tribunal as the fact-finding tribunal. So, my lords, I'm in your hands in relation to any guidance that you feel the need to issue in relation to it. If you feel that there is a risk that is raised by the First-tier Tribunal's judgment, and in particular paragraph 39, there is no objection to clarification being given in those terms, because the CICA is in full agreement with the appellant that paragraph 35 does not exclude the possibility of an extension being part of an adaptation.
Thank you.
Apologies, I'm just checking my notes to see if there are any other points that I had missed.
You want to turn around and check that those behind you, that's fine as well.
Well, I think I've covered all the points that I had in terms of responsible and friend submissions. There is just one slightly broader point that I would raise.
Yes.
And that is referenced in my skeleton argument, but I'd just like to expand on it a little bit. And that is that, in particular, when looking at the cost of the extension or adaptation, that is a investment in a property that is not owned by the applicant. We don't know what the costs of it are. Obviously, those things can vary very wildly in terms of what they cost. This case, as it would appear from what we can see of the original determinations, and I note from the history given in the First-tier Tribunal decision that this is a case that obviously initiated in 2005, so a very, very lengthy journey to get here, unfortunately. In this case, it doesn't appear that the applicant is anywhere near butting up against the cap of the £500,000 limit on overall awards, but that won't be true in every case. And in my submission, paragraph 42 and paragraph 42b in particular, which we are concerned with, is to do with compensating the child applicant for the loss of their parents. So if they need to buy in services to replace the care that a parent would have given them, they have the money available to do that. Compensating the cost of extension or adaptation in a case like this, which could cost tens, be £100,000 depending on property, and leaves a beneficial interest in the property owner, not the applicant, comes at the expense of room in that overall cap of compensation that would be available to the claimant. And in this case, I don't say that that's a particular concern because it doesn't look like the applicant's anywhere near that cap and we know nothing about the cost. So I'm not suggesting it's a factor that weighs here, but I do say that the fact that it doesn't vest any beneficial interest in the applicant is a sense check against that being the right interpretation of the paragraph, because this is about compensating the child for their loss. It is about giving them access to funds that can be used to replace that loss. And compensating that type of claim doesn't achieve that aim at all. So that was just a final thought that I wanted to add, unless there's anything else that I can address your clarifications.
Can I ask how common are appeals against claims? Is it? It's striking. There's not much litigation, not many reported cases. Are there lots of litigation over these issues?
Well, I'd have to turn my back in terms of overall
I think
numbers.
there may be an answer to that question.
In relation to the issues canvassed here, very little to none. I think we're aware of no other appeals on the points. I'm afraid we don't have statistics in relation to the overall number of appeals. I can't assist you with that.
My lords, just very briefly, just 2 points. Was your lordship referring to appeals to the Court of Appeal? Or
No. I was wondering how much litigation there was over this scheme generally. I don't
Oh, I don't know. Yeah, well, suffice to say that I think it's an area of specialism for a lot of counsel, including my junior. My lords, just two very broad points. First of all, in respect of the discussions about paragraph 41, they were actually subject to similar discussions at the First-tier Tribunal, and the conclusion, if I could take your lordships to the core bundle, page 125, paragraph 35, and if I could ask your lordships just to read that paragraph. And the arguments which preceded that conclusion can be found at paragraph 12, 13 and 14 at page 121.
Yes, well, 35. It's obvious as far as it goes, and it's a question of where you go next.
Yes. Secondly, my lords, in respect of the submission made that parental services are just contained under paragraph 42A of the 2001 scheme, in my respectful submission, is simply wrong. Paragraph B provides very clearly the provision for other payments to be made for other resultant losses. An ordinary interpretation in my respectful submission makes that argument good. But insofar as it's being said that the provision of housing needs is not a provision which benefits a disabled child, in my respectful submission is quite a stark argument. Because if it's being said that the adaptations to a property which are made as a result of the needs that arise out of the disability of a child do not benefit the child, that as an assertion is simply wrong. They plainly benefit the qualifying claimant in this case. He directly benefits from the adaptations to the property, in particular the adaptations for ground floor toileting facilities by reason of his incontinence. And he benefits from the other adaptations provided by way of the litigation threat. And it comes back, my lords, to the simple proposition that when it comes to parental services, one just doesn't look at a simple interpretation that a parent just cares for a child. That provision of care that a parent provides, or parental services, must be considered to be tasks undertaken for the child, for their physical, psychological, for instance, social and emotional protection, development and advancement. I mean, that's the basic criteria, in my respectful submission, or definition, if one was to define it, as to what a parent provides by way of services. And that, if that is right, then the fatal guide issued by the CICA, which I've taken your lordships to at page 127, and the fatal guide of 2005 and 124, explicitly provides for the possibility of additional costs for looking after a child to include childcare and loss of earnings, suffered, I quote, suffered by an adult looking after a child. Well, that's exactly what's happened in these set of circumstances, my lords. The adaptations were required to look after this very disabled applicant or qualifying claimant. And that's exactly the interpretation that Begley refers to at page 312, where she gives the example of extensive care arising from a disabled child, where the deceased parent would have provided that, and that is now provided by another. So that care can't just be categorised as physical care. That care arises out of an assessed need under the Care Act, and that need can include needs relating to property and adaptation. For those reasons, I just reinforce the point that in my respectful submission, paragraph 42b can be interpreted to include adaptation meeting a pre-existing need and the court protection costs arising. Unless I can assist you any further.
Thank you all very much. We'll reserve judgment, not for too long. When we send out a draft, you all know this, but I still have to say it in every case. Firstly, the draft is sent out for correction of typos and obvious errors, not re-arguing the case. Secondly, it's confidential to the parties, including Dominic and his litigation friend, and to those who need to know on the CICA side until it's formally published. If counsel, in the case of Mr. Karim and Ms. Skander, it's either or, if counsel are not going to be available in the near future, for example, after the beginning of August, would they please email the listing office today an alternative point of contact for receipt of the judgment, so that somebody is in a position to deal with it.
Of course.
Thank you all very much for your assistance.